Hello everyone, Ricky Rathore here, broker of record at RE/MAX Empire and real estate lawyer at Rathore Baig Professional Corporation. I just had a phone call from one of my old friends who had indicated that the existing owner of her rental property intended on transferring the ownership of the property to a child of theirs, or in the alternative, the child may be just moving into the property. And so there are some questions that I thought I would quickly address in this video because it is very useful information. First and foremost, a deeded owner for the property has the right to do whatever they want with it. If they assign or gift or give away their property and transfer it to their child, that's within their right. You can't really stop anyone from doing that. Should they do that, the lawyer on the record would simply issue a letter to you as a tenant saying that the transfer of the ownership has been completed and that any future checks would be then directed to the new owner or landlord at that point. Do keep in mind, if the owner wants to come in to inspect the property, that inspection or showing has to be between 8 a.m. and 8 p.m. They have to give you 24-hour written notice. That means providing you notice in your mailbox, in hand, under your door. It's very specific. They can't, for example, send you a text message or an email. That wouldn't be sufficient. So do keep that in mind. You do have rights as a tenant. If your landlord shows up without giving you that sort of notice, it's an actual unreasonable interference with your reasonable use and enjoyment of the property and may give you grounds to recourse under the Residential Tenancies Act. Now, moving to the second issue at hand here. So first and foremost, if the landlord wants to move into the property, the Rent Fairness Act, which is kicked in and now is read in line with the Residential Tenancies Act, requires that should somebody give notice for personal occupancy, they have to either find an alternative accommodation for the existing tenant or pay them 1 month in rent. Now, it's really important that you understand that personal occupancy means self as a landlord, landlord's spouse, their children, their parents, or somebody who's a support worker or live-in caregiver to one of those persons. A brother does not qualify. A best friend does not qualify. It's a very specific provision intended for a very specific reason. Now, with that notice in mind, either if a landlord wants to move in during a fixed term tenancy, they have to give you 60 days notice from the expiration. So if I've got a lease starting January 1st, it's going to expire 31st of December, but it automatically rolls over month to month. And so if the landlord wants you to leave as of the 31st of December, they have to give you 60 days notice from the 31st of December saying, on 31st of December, I need you out because 1st of January, I'm moving in, my spouse is moving in, someone's moving in, so on and so forth. So that's the first thing. If they're exercising that right, they have to either find you a reasonable alternative as a tenant, or they have to compensate you with 1 month rent. The second option here is that if they've sold the property, there has to be a valid and binding agreement of purchase and sale. They can't just tell you that they're listing the property. Listing the property is insufficient. They have to have a firm, meaning unconditional and binding agreement of purchase and sale entered into. Using that document, they can then serve the notices required under the Residential Tenancies Act to have the property vacated, again at the end of the lease term. Now, if the property is actually being sold, the landlord is not required to compensate you and does not have to accommodate you. They give you 60 days notice from the date of the expiration saying that on 31st of December, we need you out, we've sold the property. If you find out that the landlord has lied, you do have recourse under the Residential Tenancies Act with the Landlord Tenancy Board. An individual can be fined up to $25,000 for such an offense. And if it's a corporation that's a landlord, up to $100,000 for such an offense. So if you're a landlord watching this video, please appreciate that you've got to be very careful with what you're doing. If you're entering the property, it's 24-hour written notice between 8 and 8. The only exception to that being if your tenant has given you notice. Tenant says, landlord, I'm leaving 31st of December. That means now you can show the property between 8 and 8 by providing reasonable notice. And some have suggested reasonable notice in such an instance might include a text message or an email. That may be possible. So ensure that your showings are between 8 and 8. If the tenant hasn't served notice and you're going in, you've got to serve them written notice in hand, under the door, in the mailbox, so on and so forth. If you're selling the property, you don't need to compensate the tenant. If you're simply moving into the property, you do have to compensate. As a tenant, again, you have the right to reasonable use and enjoyment of your property. You can't interfere with the landlord's request to visit the property if they've complied with the notice provisions. You can't be forced out of your home unless the landlord specifically or the people that I've identified are moving in, or the landlord has sold the home. There are other options to have the property vacated, but we will discuss those in another video. I hope this video helps. Like, comment, share. We'll see you again on the next one.